There really are two different areas in which morality can inform the law, and sometimes the law informs morality. So the first one that we think of is the idea of what's called legal moralism, the idea that the law should reflect traditional moral values, that if the Bible says that it's a sin to engage in fornication or adultery or incest or sodomy, then the law should follow that. And that's sort of the traditional approach that the law in the West followed until relatively recently. Even as late as the 1960s, the famous debate between H.L.A. Hart and Lord Devlin in Britain was over this question of what's the proper role for the law to regulate morality. In that case, they were looking at prostitution and homosexuality. That now seems somewhat anachronistic, that view. And by the latter part of the 20th century, we saw that we were moving away from that kind of moralistic approach to one that reflects more liberal values in a pluralistic society where people wanted to pursue their own interest, where we have different religious traditions and different kinds of social orderings. We wanted to give people the opportunity to do that, so long as they didn't run into other people's rights, so long as their behaviors didn't have a deleterious effect on other people's ability to exercise their rights, whether sexual or otherwise. So we see this sort of movement towards liberalism and away from legal moralism, although there are those who still espouse the values of legal moralism. Justice Scalia, for example, famously in his dissent in the Lawrence versus Texas case, in which the Supreme Court legalized or found constitutional protection for same-sex sexual behavior, Justice Scalia really adhered to a view that Lord Devlin would have been quite comfortable with 30 or so years earlier. So that's one sense in which the law is informed by morality. The other one, though, is that one is problematic from the perspective of a liberal. But the other one, I think, is quite consistent with the liberal values, and that is the notion that we should not impose criminal punishment on people unless they deserve it, unless they engage in wrongful behavior. And that's the notion of what we call negative retributivism, the idea that that we should only punish people who actually do bad things and wrong things. And by wrong things, I mean wrongs to other people, wrongs that impact other people's rights. And that's a moral judgment that we make. We have to make judgments also with respect to what's proportional punishment. We have to make judgments about why rape, say, is a more serious offense than indecent exposure, assuming that it is, or why it's worse to impose non-consensual sex, say, on a child than on an adult. I believe that it is. Those are moral judgments that we make, and there's nothing moralistic in the traditional Lord Devlin sense of the term, but nevertheless, those are moral judgments, and I think those are moral judgments that most liberals would embrace and believe are appropriate within a criminal law. The question is, we may disagree, though, about the specifics of it. People may disagree about which is a more serious offense or how we should grade a given offense from the views of others.